Hello and welcome to the Herrington Carmichael Employment Law Update for October 2018. I'm Alistair MacArthur, I'm the head of the employment team with Herrington Carmichael, and as always I've got the 4 key subjects for you for the last month. So where to start? Let's start with the Parental, Bereavement, Leave and Pay Act. This was enacted in the last month and it's due to come into effect in 2020. I find this quite surprising this wasn't already law, but what we have is we have a piece of legislation which now deals with circumstances where an unfortunate occurrence happens whereby parents lose a child in their employment. What this means is that where they have a death of a child, they're going to have a period of leave of up to 2 weeks and that's going to be paid. We need to wait and see what the level of pay is going to be, and whenever we have some development on this we will let you know. Let's move on to a couple of cases now. Let's firstly deal with the case of East Kent Hospitals and Levy. This case relates to resignations and the clarity that is given in a resignation by an employee. Now, as an employer, you will know that often employees will just write to you and say, I resign. However, often now employers should be exploring the background to the resignation and what's taking place. In this case, Miss Levy gave her employer notice to change from one hospital department to another. The employer started to treat that as a resignation, and ultimately when the change in department fell through, Miss Levy tried to retract that resignation. She was not permitted to do so and effectively was dismissed. Now, this may sound like a very fact-specific case, and it probably is. However, from an employer's perspective, if you have an employee who gives you a letter which is not entirely clear about their intentions over leaving their employment, it's always worth going back and asking some questions and making sure you clarify what their actual intentions are. If you don't, you could end up dismissing them. Let's move on. Let's move on to the topic of Cheapy, the case of Tabera and Mears. This case relates to a travel allowance which was from 1958, and following a transfer to Mears Limited, a group of employees tried to argue that the removal of that travel allowance was void because of Cheapy. However, they were unsuccessful to do so. And the reason they were unsuccessful is the removal of the travel allowance was not because of the transfer. From an employer's perspective, it's always important to ensure that post-transfer you're changing terms for the right reasons and not for a transfer-related reason or because of the transfer. If you need some advice on this and to get your reasoning right, please do let us know. It's something we deal with quite regularly and we'll be happy to discuss it with you. Finally, a piece of HMRC guidance. Now, where a penalty is imposed for a failure to pay national minimum wage and then a transfer occurs under the Cheapy, previously the penalty would have remained with the transferor, so the original employer. However, HMRC Guidance has now confirmed that the transfer will actually mean the penalties go over to the transferee, so the recipient employer will also have the penalty come to them. Now this feels really harsh, however from a perspective of a transfer, it is concurrent with the law. So what does this mean for you? This means that if you're in a transfer situation, you need to get your due diligence right. You need to make sure you've properly explored what happens pre-transfer and that employees have been paid the appropriate wages at either the minimum or the living wage rates, so that you avoid the liability and the penalties coming over to you. That's it from me this month. I'll be back in November. Thank you very much.